Hi, my name's David Fortney, and welcome to our employer compliance updates. Joining me today is Judy Kramer
Hello.
and Bert Fishman.
Hi, thanks for joining us, folks.
We're really glad to be here, and what we want to talk to you about is our upcoming quarterly briefing. And that's a briefing that we're providing on what's going to happen during the second quarter of 2015, which promises to be a very action-filled quarter. In addition, following today's program, we are going to provide some additional programs that delve into some of these developments in more detail. Those include a program on April 23 involving new obligations of federal contractors, May 14 for an EEOC update, and June 11 in dealing with government contracting addressing the FAR. But for today, let's just talk briefly about what we're going to cover in the quarterly briefing that's coming up. And Bert, let me start with you. What's hot?
Well, I think the hottest thing on the regulatory agenda are the so-called blacklisting regulations, implementing the President's executive order. These are regulations that will require all potential government contracting bidders to disclose a huge raft of allegations and violations under any federal or state labor law. We believe that the compliance burden is going to be enormous and the impact will be extremely large.
And you anticipate is your information, those regulations are coming this quarter?
I think they'll be coming out in the next 60 to 70 days.
Wow, okay, this is one we've been worried about. Judy, what do you got on your list?
Tops on my list is also a set of proposed regulations, and these are the new overtime regulations that should be issued by the Department of Labor later this spring. I would anticipate that the Labor Department will publish these proposed regulations by the end of June, and we anticipate that they will greatly increase the number of employees that are non-exempt under the Fair Labor Standards Act, meaning that they will be eligible for overtime whenever they work more than 40 hours in a work week. I think the Labor Department will do this in a number of ways, primarily by raising the threshold for who's considered exempt. Currently, an employee has to earn at least $455 a week, which is roughly $24,000 a year, in order to be exempt. That threshold is undoubtedly going to be raised substantially so that many more people will be considered overtime eligible. And I think there'll be a number of other changes, but I think that's the primary one that we need to look for.
Well, those are both pretty fundamental changes in the offing for employers, and those rulemakings will be important. Bert, what else? Do you have anything else that you're looking at?
Yes, I do, and it's in a different area. It's in the realm of the National Labor Relations Act under what most people think of as union organizing, but the most important and most controversial, I think, is the publication on April 14th of the so-called quickie election rules. The main impact of that is that union organizing campaigns will be very truncated, perhaps as little as 2 weeks, with a number of other exclusions, so that there will be very little opportunity for an employer to delay the proceedings. So if you have any fear of being organized, the only way to get ready for the regulations is to be ready today.
And those are going to be final regulations?
Yes.
Is that what you're saying?
Yes,
Wow.
the final
Okay.
regulations will become effective on April 14th. There are already lawsuits filed to try to challenge them, but you know, you can't bet on a judge. If you
Right.
have concerns about being organized, you should be ready today.
Prepare now. Agreed. Okay. Judy, what else you got?
I would note also that the Equal Employment Opportunity Commission, the EEOC, is likely to publish proposed regulations during this current quarter regarding employer wellness programs. The EEOC has recently taken a very hardline stance with regard to wellness programs and has brought several lawsuits against such plans on the basis that they are not in fact voluntary, that employees are given incentives to sign up for wellness programs, or disincentives if they don't do so, and that this violates the Americans with Disabilities Act. This puts the EEOC at loggerheads with the White House and the Affordable Care Act, which of course is the President's signature piece of legislation. The Equal Employment Opportunity Commission, EEOC, has recently sent proposed regulations to the Office of Management and Budget for review. We would expect that they would soften the EEOC's position with regard to wellness plans and make EEOC's position much more in line with the President's and the Affordable Care Act.
EOC is often referred to as a semi-independent agency.
Yes.
They may have been reading the word independent, now they've learned to read the semi part and be more in line. Well, we'll see. One other thing I think we should talk about also in our session is the new task force that the chair has pulled together to deal with harassment, an important topic, and the new EEOC chair, Jenny Yang, is I think going to make that one of her signatures also, so affordable care and harassment. All right, and there's always lots of OFCCP enforcement, seems never ending and accelerating, and so we'll delve into that a little bit too. So we hope you'll join us. These briefings are coming up on April 2, and then there'll be future more detailed ones, and we're looking forward to having you join us. Thank you.
Thank you.
Thank you very much.